Hello. Let's talk about the situation when somebody died not in Quebec and the state was open not in Quebec, and the executor and the whole process of the estate settlement, liquidation, is not in Quebec, but there are assets in Quebec. And to get access to those assets, be it a real estate, property, land, some condo, part in some division, some apartment, a building, a commercial or residential or whatever, in such or bank accounts or something in a safety deposit box, but still located in Quebec. And to get access to that, especially when it comes to real estate, but also to bank accounts, the will, the document, or if somebody died even without a will, the authority of the executor, liquidator, trustee, administrator, whatever the word, should be confirmed here in Quebec. The document issued by the court there is not enough. A local notary will not proceed with the title transfer for the property without local confirmation. The banks will most probably not deliver. Some investment companies, there might be problems. So the situation where an executor in some other jurisdiction, in some other province in Canada or in the United States or in Europe or elsewhere, when such sometimes in Australia, even in New Zealand, needs to have his or her authority recognized in Quebec to deal with the assets, that situation is not unusual. And in such a situation, the question is how and how long will it take to get this authority, usually by a will, to be recognized in Quebec. There are several potential problems about that. First of all, in many other jurisdictions, different documents, many kinds of documents, are available as a last will, some trusts agreements, some survivorship clauses, which are not per se valid in Quebec as a will. Many foreign wills, at least those I could have at hand, they contain an external clause referring to some other document, often again to some trust agreement, for example, which is validity of such a clause is questionable in Quebec, and it might be a problem. Also, sometimes a will made in some other jurisdiction simply does not fit with a strict description by the Civil Code of Quebec what can be a will. And even if that document is a valid will elsewhere, it can be not one here in Quebec. So, what can be valid in Quebec as a will made elsewhere? In Quebec itself, there are three kinds of valid wills. One of them is a will made before notary here in Quebec. So this one is excluded if we are talking about a will made elsewhere. There are only two other options. A will made before two witnesses. And usually when a will is prepared by a notary public or by a lawyer somewhere elsewhere with that person's signature and another witness signature, then technically that will go as a will signed before two witnesses, as long as it was signed by those witnesses at the same time and the same place with the testator. It technically goes as a will in Quebec. But again, normally in many jurisdictions it's the same, but not everywhere. With such a will, there should be an affidavit of at least one of the witnesses attesting that, yes, both witnesses signed same place, same time, and they saw the testator signing and so forth. Because in some jurisdictions, for example, those people can be signing later on or just take the testator's word that, yes, I signed, now please sign. But as long as the dates are different, or as long as there is no such an affidavit, it might be a problem. Or, for example, a will was done decades ago. Now nobody can even find those witnesses, because very often witnesses are not people you really know. It's just somebody called by your lawyer or by a notary, just help us, just sign here and here, and you forget about those people. Now, how do you find them? So, in the absence of such an affidavit, probate of such a will be problematic and most probably require at least a forensic report attesting to the validity of the signatures. And again, there should be sometimes even some like private investigation regarding the personalities of those witnesses. And even then, it might not work here in Quebec. When a will is handwritten, well, if there is a good luck that the person, the testator, really written everything, starting with the date and finishing with the signature, with his or her own hand, explicitly stating that this is the last will and testament, and this is meant to be, and that everything previous is specifically revoked, and now only this is the last one, and so forth. Again, with a proper affidavit attesting that the handwriting is that of that person. Sometimes, again, a forensic expert report is required. It will probably go, but as you can imagine, if the will is not that clear, if the text is not that clear, and at least those handwritten wills I saw, they're usually not entirely clear. There are some strange phrasing. Something is omitted, for example, who will be the executor, or that the previous wills are revoked. And whatever is not mentioned in this handwritten will, if the previous wills are not revoked, still goes by the previous will. So you can see the complication here. Therefore, Quebec judges usually are not very fast to probate those unclear wills, let's put it this way. But even if that all goes well, there might be relatives in many other places. And to go with this Quebec probate, at least with Quebec probate, all those persons have to be notified, even if they are not in the will, but they might be heirs but for the will. So all the interested, concerned persons should be notified, and the proof of such a notification, and here we go by the complexities of notification by Hague Convention requirements in certain countries and so forth, you can imagine the length and the cost of the process, even if nobody contests. And now let's imagine that somebody does contest. That adds to it all. And all that only to get, let's say, 12,000 from some local bank that might not even be worth it, as you can imagine. Therefore, sometimes some people, some lawyers, we try to go by way of recognition of foreign judgment, because a foreign probate, not always, but often can go as a foreign judgment. But there is a caveat here again, because, well, what is the advantage of that? Because when it comes to recognition of foreign judgment, the local judge, the Quebec judge, doesn't need to go into all the fine details and all the facts again. He or she only, at least by the Civil Code of Quebec, has to verify that the judgment was rendered properly in that jurisdiction, and that it does not go against public order in Quebec. So there is no, let's say, something criminal in there. But, as I said before, there is a caveat. The previous judgment, the probate in that other jurisdiction, should be final and non-appellable. And in many jurisdictions, those letters of administration issued together with probate, they're all temporary. Not all, but in many jurisdictions. Meaning that no judgment is final. And in many jurisdictions, by the letter of the local law, those letters of administration, the probate itself can be revoked by the judge, by the court, if some new information comes or if somebody contests on the go, which is different from Quebec procedure. Therefore, often we cannot, as lawyers, we cannot even obtain such a document from a foreign jurisdiction that the judgment is in fact final and non-appellable, because it's not. Not to mention that not every foreign court is ready to provide any certificate of the finality and non-appellability of the judgment, even if it is final and non-appellable. So again, we have a problem. This is why often, even if it's successfully underwent probate in some other jurisdiction, in Quebec, it's all new. It's a new probate, not simply a recognition of a foreign judgment. Unless, again, there is a conclusive proof that the judgment is final and non-appellable. And we are back to that issues of affidavits, forensic experts, notice to other people wherever they are. Even if it goes in Quebec by a simplified procedure, because if nobody is contesting, it's technically possible to go with a probate not before a judge but before a notary, a local Quebec notary. But the procedure should be followed anyway. And for a notary, it's even stricter, because the judge can make a decision just compensating for some lack of clarity because he or she is a judge. The notary cannot do that. The notary has to see everything clear before the entire probate goes, and we are back again to all those like technicalities, because even if the text of the will is clear, but it is not complete in a sense that somebody said, well, everything goes as it is said in my trust agreement, then the will itself is valid, but the trust agreement is not a will. So what's in the will, what's not in the will is debatable again in Quebec, as you can see. And there is no, at least to my knowledge, there is no like uniform, universal, unequivocal way to deal with those things. So some judges, so it's case by case, depending on all the like ensemble of the facts, how the judge would see it. So, as you can see, out of nowhere, recognizing an executor's, a liquidator's authority from some other jurisdiction might become a problem in Quebec. What can be advised if you're fortunately still alive and only envisage that some of your assets, while you are not a Quebec resident, might need distribution and collection in Quebec? As one of the ways, again, for particulars, do consult your own lawyer. By way of general information, one of the ways might be to prepare in Quebec a specific will for Quebec before a Quebec notary, so it will be valid without probate in Quebec as is. And in your general will elsewhere, specifically refer that that will is valid for Quebec and covers all the assets in Quebec. So that in those jurisdictions where external clause is valid, that will be okay. And for Quebec, it will be okay for Quebec. But when in that foreign will you're like routinely mentioned that I hereby revoke all the previous wills, it might be, just for the sake of clarity, might be a good idea to specify that the Quebec will, the will that you prepared in Quebec for Quebec, is not hereby revoked. It continues to be valid, so that in both jurisdictions, for all your relatives or heirs, there will be no question about that. Otherwise, they might be facing like years and years of litigation. And the outcome of such a litigation, you never know. Thank you, and have a nice day.